You're driving in Florida, you get pulled over. The officer leans into your window and says those words, "I smell marijuana." A few years ago, that sentence almost guaranteed a search of your entire car. Today, the answer to what happens next is more complicated, and most people don't know why. Florida legalized medical marijuana. The federal government legalized hemp. And those two changes created a legal problem that Florida courts are still fighting over because the smell of marijuana no longer automatically means a crime is being committed. And the gap between what police are doing at traffic stops and what the law actually allows is where people are getting hurt. In this video, I'm going to walk you through why the "I smell marijuana" game has changed in Florida and what recent court rulings actually say and exactly what words to use when an officer tells you they smell marijuana during a traffic stop. Why the old rule is falling apart. See, before medical marijuana and legal hemp, the logic was clean. Marijuana is illegal. If an officer smells something illegal, they have grounds to search for it. Simple. That logic worked perfectly when all marijuana was considered contraband. But Florida now has medical marijuana program covering hundreds of thousands of qualified patients. And since Farm Bill, hemp, which smells and looks identical to marijuana, is legal under both Florida and federal state law. So when an officer says, "I smell marijuana," what are they actually smelling? It could be a medical patient with a lawful prescription in their car. It could be legal hemp flower. It could be illegal marijuana. The officer cannot tell the difference by smell alone. Nobody can. And Florida's appellate courts have started saying exactly that. What Florida courts have actually ruled, this is where it gets real, and this is what most people don't know. In 2024, Florida's 5th District Court of Appeal issued an en banc decision in a case called Baxter v. State. The court held that because marijuana odor is no longer immediately apparent evidence of criminal activity, the smell alone is not independently enough to justify a search. It can be a factor, but it cannot be the only thing police rely on. Then, in October 2005, Florida's 2nd District Court of Appeal went even further in Williams v. State. That court, also sitting en banc, ruled that the plain smell of marijuana alone no longer establishes probable cause for a vehicle search. These are significant rulings from two of Florida's district courts of appeal. But here is what you need to understand. The Florida Supreme Court has not yet issued a single statewide ruling resolving the question. Different districts are moving in the same direction, but until the Supreme Court speaks, there is still going to be variation in how judges across Florida handle this. What I can tell you is this: police have stopped using the smell of marijuana as justification for searches. They are still doing it every day. And until the law is fully settled at the highest level, you need to know exactly what to say at that traffic stop. What can still get you in trouble? See, here's a mistake I see people make. They hear about medical marijuana and legal hemp and assume they have nothing to worry about. There are still clear ways this goes wrong. Because if you're not a qualified medical marijuana patient and you possess marijuana in Florida, that is still a crime. Possession of 20 grams or less is a first-degree misdemeanor. More than 20 grams can be a felony charge. If you are a medical patient, you still have restrictions too. You cannot use marijuana in a vehicle. You cannot use it in public places. Your product must be in the packaging from a licensed dispensary. And a DUI is still a DUI regardless of the substance. Driving under the influence of marijuana, whether you have a medical card or not, is still a serious criminal charge in Florida. There is no legal THC blood limit like there is for alcohol. Instead, the standard is whether your normal faculties are impaired, and that gives officers and prosecutors a lot of room to work with. it's legal for me is not a complete answer at a traffic stop. The context matters enormously. Here's what you need to say when they say they smell marijuana. Here are the exact words. When an officer tells you they smell marijuana, you say, I don't consent to any searches. That's the line. That's all of it. You don't explain yourself. You don't say, I don't have any marijuana. You don't say, I have a medical card. You don't pull out your phone to show them anything. You say, I don't consent to any searches, because your explanation is not going to help you at the roadside. Once you start explaining, you're talking. And once you're talking, things come out, details get misremembered, that story gets really complicated. And what ends up in the officer's report may not match what you thought you said. Your statement of non-consent is clean. It's on the record, and it matters later. What happens after you say it? If you've clearly stated that you don't consent to officer searches anyway, do not resist, don't argue, don't touch the officer or attempt to block the search. Let them do what they're going to do. You stay calm, observe everything you can, and the moment you're able to, call an attorney. And here's the important part. Your statement of non-consent does not automatically mean that evidence is going to get thrown out. If police had an independent, lawful basis for the search, say like a warrant, or they saw something in plain view, or you were being arrested, the search may still hold up. But if the only thing they had was the smell, and you clearly stated you did not consent, that becomes the centerpiece of a suppression challenge. The Baxter and Williams decisions are tools your attorney can use, but they only work if you said the words first. The difference between smell and plain view. There's one more thing worth covering here. If an officer looks into your car and sees marijuana or paraphernalia sitting out in the open, on the seat, in an open container, or visible through the window, that is a different situation entirely. Plain view does give police a basis to act that doesn't depend on the odor argument at all. What they can actually see becomes evidence independent of what they claim to smell. So if you're a medical marijuana patient transporting your product, keep it completely out of sight, in the original dispensary packaging, in a closed bag, in the trunk, not sitting on the passenger seat, not visible through the window. That is practical information about how the plain view doctrine works under Florida law, where this is headed. So here's where we land. Florida's legal landscape around marijuana has shifted because of medical marijuana legalization and legal hemp. That shift has changed how courts view the I smell marijuana justification for vehicle searches. Two major appellate courts have already ruled that odor alone is not enough. But recreational marijuana is still illegal in Florida. The 2024 ballot measure to legalize adult use did not meet the 60% threshold required to amend the state constitution. So possession outside of the medical program remains a criminal offense. In my experience defending clients, the people who were best positioned were the ones who understood their rights and used them, who said clearly they didn't consent, rather than the ones who tried to explain or tried to argue their way out of the situation at the roadside. If this video helped you understand where the law stands right now, watch the next one. What actually happens when you refuse a breathalyzer in Florida? Because that decision has consequences most people don't know until they're already facing them. And if you need to talk through a situation, our number is in the description.